All right. Hello and welcome. I'm Otis Landerholm. I'm the founding attorney here at Landerholm Immigration A.P.C, where we fight for your American dream. And today I want to talk about marriage fraud. All right. And specifically, I want to talk about a case that came out in October of 2020. And we all know about 204C. Have you heard of 204C? 204C is a fraud finding, and it basically says that if there was ever a fraudulent marriage, meaning you entered into a marriage solely for the purposes of immigration, not because you wanted to form a life together, but just because you wanted to get some kind of immigration status. If you had that in the past, then future immigration petitions cannot be approved. Get it? That's what 204C stands for. And in some instances, it's a pretty harsh rule. Like, I don't care how much hardship your spouse would go through if you don't get a green card, like no matter what, that petition is not going to get approved because of 204C. Okay? Now, in theory, in order to have a 204C fraud finding, the government has to have substantial and probative evidence that there was marriage fraud, that there was a marriage entered into solely for immigration purposes. But if they have that, then they are, then they will have to deny any future petition for you. So it is a pretty harsh law against people who, even if 20 years ago there was that finding, there was that one marriage that you did when you were 20, and now you're 40 and you've got your family, right? Still, that petition cannot be approved. All right, so what's this case? The matter of A.P.C, all right? It was decided by the Board of Immigration Appeals on October 30th of 2020. So here's the question. The question is, what if there was never even a finding all those years ago of marriage fraud? What if they just denied that first I-130, that first marriage-based case, because there wasn't sufficient evidence submitted? It wasn't a finding of quote-unquote fraud. It was just like, hey, you didn't submit enough stuff to show that you had a bona fide marriage, so we're denying it for that reason. And now all these years later, you're married now to a new spouse and you're trying to file for your green card now. Will they still hold that first earlier marriage against you? All right. Even if there was no 204C fraud finding in that earlier marriage. And unfortunately, the BIA in this case says, yes, they will hold it against you. So if that first marriage-based case, right, was denied for lack of evidence, but if today you're filing under it with a new spouse and they will ask questions, all right, they'll say, hey, who was that first husband? Who was that first wife? How long were you married? Tell me about that marriage, all right? Were you intending to form a life together when you first got married, or was it just for immigration purposes? Oh yeah, we were just together for, a month and a half before we filed divorce, and we filed the immigration paperwork, but it didn't end up working, and it didn't go anywhere. Hey, they might not only deny that past case, but they might have to deny every single petition that you and your spouse now ever file going forward. Okay, got it? And so that's the matter of A.P.C. You got to know about it. If you had a marriage in the past, and if you weren't married for very much time, the government views marriages with suspicion. They're like, hey, that was just for immigration purposes, and they'll take it as a violation of immigration law. And so you want to be aware, you want to be on the lookout. And so when you're preparing the future case, you want to be able to say, hey, no, all right, no, that first marriage that I had years ago, it wasn't just for immigration purposes. It might have been a mistake. It might not have been the best thinking through, But at the time that we got married, you know, maybe we were young and stupid, but we did intend that the marriage would work. All right. And that's okay if you were young and stupid, but it's not okay if it was a plan to try and get around immigration laws and if it was solely a marriage of convenience for immigration purposes. Got it? If you have questions about this, talk to a lawyer. All right. That's what consultations are all about. We can help you. We can figure out what the best strategy is in your situation because you don't want to be barred by 204C. You do not want to be barred by 204C. It is nasty. Okay. And so if we can, you know, and if that makes sense for you, please give my office a call. We'd love to do a consultation with you. If this video was useful, please subscribe to our channel. Please give us a thumbs up so that we know that you like the video. We can create more about similar topics. If you have a idea for a topic you want us to do a video about, please leave it below this video here on YouTube because we love hearing from our viewers. All right. So thank you so much for being with me. I'm Otis Landerholm. I'm the founding attorney here at Landerholm Immigration A.P.C, where we fight for your American dream. Have a great day. All right. Bye-bye.